Welcome back to the Constitutional Clarion. For those of you who believe that governments are corrupt and breach the law, and there were many of you in the comments on my last video, I think you'll actually enjoy this one. It deals with unlawful government spending and the use of litigation to prevent transparency to the public. In fact, it's a follow-up on two videos that I did previously about a case brought by the former Senator Rex Patrick seeking under FOI the advice that the then Attorney General Christian Porter gave to the then Prime Minister Scott Morrison in January 2020 about what became popularly known as the Sports-rorts affair. That FOI request was initially refused, and after quite a lot of faffing around, it was rejected on the basis that there was by then a different Attorney General who did not hold the relevant document. Now, this is a ploy that governments use to prevent access to controversial documents. Those documents are kept in the office of the minister and not on government files, and then they are destroyed or taken by the minister when he or she moves to another portfolio or loses office. This prevents the people from getting access to those documents through FOI. Rex Patrick challenged that particular practice in this litigation. In my first video about it, which was called Stop the Shredders, I discussed the judgment of Justice Charlesworth in the federal court in the case of Patrick and the Attorney General. She held that once an FOI claim is made to a document, its status as an official document of the minister is determined at that time, and it doesn't change even if that particular minister leaves office. Second, she said that there was a legal obligation on the minister or the department to ensure that the document is retained and made available for the purposes of any review or appeal until the process is completed. She said that a minister could not refuse access and then destroy the document to thwart any review. Justice Charlesworth stated that information held by the government is a national resource to be managed for public purposes. A document held in an official capacity, she said, is not the property of the person who happens to hold the office of minister, nor of the political party to whom that person happens to belong. It's not the property of the government of the day, that is, the Morrison government, because there is no such legal entity capable of owning property. When a person ceases to hold the office of minister, he or she has no personal entitlement to maintain possession of the documents previously held in his or her official capacity. Now, I'm just going to stop there and tie that back to my last video, which explained about legal personality and that it's not the executive government that is the legal person that can own property and fulfill all those other legal powers and duties, but rather it's the Commonwealth of Australia as a polity that is the one with the legal personality that can do that. This is the point that Justice Charlesworth was making, that the Morrison government is not a legal person and cannot own documents. They instead belong to the Commonwealth of Australia and must be made available under the FOI Act unless they fall within a valid exemption. Now, this decision was then appealed by the Albanese government, the Labor government, so both sides here have been involved in trying to prevent government transparency. But the government lost again with its argument, this time before the full court of the federal court in Attorney General for the Commonwealth and Patrick. The full court agreed with Justice Charlesworth that the status of the document was determined at the time the FOI request was made, and it doesn't change because the minister leaves office. Their Honours also accepted that there was a duty not to frustrate the right of the requesting party to have the request determined, including on appeal or review, and that this was necessary for the provisions of the FOI Act to be workable and to achieve their objects. How that duty was to be given effect, whether by the department keeping the document or by some other procedure, was not for the court to determine. It was enough to require that that duty be met. Now, the upshot of all of that is that governments cannot use a change in minister or a change in government as an excuse for shutting down an FOI request. Ministers may not frustrate the operation of the Act in that way. A mechanism has to be used to ensure that documents subject to FOI applications are preserved and able to be produced in response to that application throughout the process until all appeals are finished, regardless of who the minister is or which party is in office. During much of this process, it was actually claimed that this advice could not be found, despite arguments that it was a cabinet document, in which case it should have been recorded and registered in the cabinet system and been available, and also claims that it was a legal advice. However, along the way, someone in the government fessed up to actually having a copy of the document. So it was possible to release it, and that was back in play. The question was then whether the Commonwealth would seek leave to appeal to the High Court. It probably concluded that it would get a third walloping if it did go to the High Court, and perhaps even a more burdensome judgment. So at this point it gave up. The document was finally released to Rex Patrick just before Australia Day 2025. So, before showing you the document in greater detail, let me remind you about what it was about, because we've probably all forgotten most of the details of this controversy. So the Auditor General investigated what was called the Community Sport Infrastructure Program and made a report to Parliament about it in January 2020, so 5 years ago. The Audit Office found that while money had been appropriated to the Australian Sports Commission, which is also known as Sport Australia, to make these grants to sporting bodies, the Minister for Sport had run a parallel process based upon other factors, such as whether projects were in marginal or targeted electorates, and determined the outcome of the grants, overruling or preempting a merit assessment by the Commission. The Audit Office reported that there was evidence of distribution bias in the award of grant funding, and that there was no evident legal authority for the Minister to be the decision maker in making the grants. In the course of the ensuing public controversy, and it was a big one, the Prime Minister sought advice from the Secretary of the Department of the Prime Minister and Cabinet about whether the Minister, Senator Mackenzie, had breached the Ministerial Statement of Standards. Now, in a report that was initially kept secret again, but eventually released under FOI, the Secretary claimed that the process was not unduly influenced by reference to marginal or targeted electorates, but that there was a conflict of interest with respect to a grant to a gun club of which the Minister was a member. This provided a convenient excuse to get the Minister to resign and sit on the back bench for a short period. The Secretary noted that he did not have access to all the material upon which the Audit Office had based its findings, and that his advice did not address whether the Minister had any legal authority for her action. He based his assessment on the assumption that she did have legal authority. If not, she would have been in breach of the requirement that ministers must act in the lawful and disinterested exercise of statutory and other powers available to their office. The Prime Minister also sought advice from the Attorney-General, Christian Porter. It's this advice that has been finally produced by the government after many years of fighting through the courts, and enormous amounts of costs involved as well. So, what did it say? The first and most interesting aspect of it is that it stated not to be a legal advice, despite the fact that that was one of the claims under FOI as to why it should be exempt. Anyway, Porter clearly didn't want to rest his legal reputation upon what he was being essentially required to produce, which was a political advice. He explained this as follows. Naturally, if I or any legal practitioner were to provide comprehensive legal advice on the legality of any particular individual grant or process, it would be necessary to obtain all the relevant facts and circumstances in relation to the particular matter. You have not requested any such advice, and it is plainly not the purpose of this letter to give any such advice. Now, that makes it pretty clear that while the Prime Minister wanted to claim to have received legal advice from the Attorney-General about the Minister's legal authority to approve grants, Porter was not prepared to put his name to a legal advice on the matter. The phrase, "It is plainly not the purpose of this letter to give any such advice," suggests that the purpose of the letter was to provide political cover. Attorneys General, and you do need to be sympathetic to them about this, do walk a very fine line between being politicians, subject to collective ministerial responsibility and cabinet decisions and political obligations on the one hand, and being law officers on the other. And that's why formal legal opinions are instead usually provided by the Solicitor General rather than the Attorney General, because the Solicitor General is not a politician in Australia. They are in some other jurisdictions, but not here, and they don't have the same political conflict. The Audit Office had said that there was no evident legal authority under which the Minister was able to approve the grants. Why? Well, the money for the grant program was appropriated not to the Minister's department, but to the Australian Sports Commission. The Australian Sports Commission is not a government department. It is, rather, an independent corporate entity established by statute. Its existence, functions and powers are determined by legislation. Its relationship with the Minister is also determined by legislation. While a Minister may have a general power to direct public servants in his or her department, subject of course to any statutory obligations and the requirement of administrative law, a Minister does not have the same power with respect to corporate entities that are established by statute. The Australian Sports Commission Act is explicit about the extent of the Minister's power. Section 11 gives the Minister power to direct the Commission with respect to the policies and practices to be followed by the Commission in the performance of its functions and the exercise of its powers. It does not permit the Minister to exercise the Commission's powers. It only permits her to direct the Commission at the higher level of policies and practices with respect to how the Commission exercises its own functions and powers. Further, any such direction must be in writing, published in the Government Gazette and tabled in Parliament. No such direction was ever made in relation to this grant program. Nor could the Australian Sports Commission delegate its powers to the Minister. Again, this is controlled by statute. Section 54 of the Act confers on the Commission the power to delegate its powers to a member of the Commission, a committee of the Commission, the Executive Director, the Director or a person employed by the Commission. There is no power to delegate the Commission's powers to the Minister. So what did the Attorney-General say about this in his legal advice? He said rightly that ministers may perform a wide variety of functions, including performing a role in the administrative functions of a government agency within their portfolio without specific statutory authority. Their authority in this respect derives not from the statute, but rather from the office that they hold as minister. Well, that's fair enough in generality. But here, it was not just another government agency. It was a separately established corporate body where the statute was very specific about the extent of the powers of the minister, and those powers did not extend to acting as a delegate in making decisions about sports grants. So how was that explained away? Well, the non-legal advice says the following. It's quite a long quote, but follow along. Ministerial direction-giving powers are common in legislation establishing statutory authorities, but they are rarely exercised. There is not necessarily any legal imperative or other requirement for a minister to use a specific statutory directions power in order to perform a role in the administration or functions of a government agency within the minister's portfolio. In the rare circumstances in which a ministerial direction is given, the purpose of the direction is ordinarily to resolve some intractable disagreement between the authority and the relevant minister. Indeed, it would be onerous and unnecessary to require a formal ministerial direction every time a minister and statutory authority agreed to a minister playing some role in the administration of the authority. As such, the Auditor-General's apparent finding at paragraph 2.19 that the absence of a Section 11 direction necessarily rendered the minister's involvement as being without legal authority is respectfully incorrect. Well, no. The Auditor-General was, with respect, correct. Why? The weakness in the Attorney-General's reasoning is that it seeks to blur the lines between ordinary government agencies within a minister's portfolio, which are non-corporate entities, and they're the purple ones on this particular chart that I showed you last time, and the very different corporate Commonwealth entities that are shown in green and the Commonwealth companies in yellow. Now note the words that used by Porter in his analysis, agencies and authorities. No, he doesn't refer to companies and corporate entities such as the Australian Sports Commission. In addition, one cannot use executive power to avoid the express application of a statute. Statute overrides prerogative executive powers. So where a statute sets out the relationship with a minister, it cannot be ignored simply because it would result in inconvenient paperwork. The very point of including these provisions is to give the relevant body a specified measure of independence from ministerial direction. So yes, this non-legal advice was a good try at fudging the boundaries so that Porter could fulfil his political function of exonerating the minister. And I'm not critical about that. He was fulfilling the particular role that he was cast in, and he made very clear that this wasn't a legal advice. Even though there was a Senate Select Committee inquiry into the controversy, at which I and other legal academics appeared and criticised the lack of legal authority for the minister's action, not a single Commonwealth official was prepared to identify to the committee the legal authority for the minister's actions. Officers from the Attorney-General's Department claimed legal privilege so that they didn't have to answer the awkward question. Nor was there any written submission from the Attorney-General's Department or any other agency that identified the minister's legal authority. There was actually a deafening and embarrassed silence about it, for obvious reasons. Even worse, the Australian Sports Commission told the Audit Office during the audit that it did not believe the minister had the authority. An officer in the Department of Health also noted in an email on the 28th of June 2018 that the Australian Sports Commission Act did not give the minister the authority to approve the expenditure unless she gave a written direction to the Commission under Section 11. The officer concluded that legal advice would be sought if the minister proposed to act this way. But no legal advice was sought. The Department of Health, the Minister's Department, said that it was the responsibility of the Australian Sports Commission to satisfy itself about the legality of the process. The chair of the Australian Sports Commission said that it was not for us to comment on the minister's legal basis for decision making. The minister herself said that any technical question regarding the statutory basis of her discretion should have been resolved by the Australian Public Service. So everyone blamed everyone else, and the only attempt to justify what happened was kept secret until January 2025, when, frankly, no one cares anymore. Well, I care. The principle of the rule of law, which underlies the Constitution, is that everyone must obey the law, including ministers. This whole sorry saga comes down to a political culture where ministers believe that they should have the power to do whatever they want, and any public servant who tells them otherwise is regarded as obstructionist and removed. Now, while I've spent the last few days refuting hundreds of conspiracy arguments in the comments on my previous video, with people claiming all kinds of corruption and treason based on nonsense arguments about corporations and seals and titles and maritime law and whether a word is printed in capital letters, they completely miss where the genuine problems lie and the failure of both political sides to address them. If you are concerned about the lack of integrity in government and failure to obey the rule of law, then you should really be focusing on other matters, such as the making of government grants and agitating to clean up the system, because then you might actually achieve something useful. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.